Good afternoon, everybody. I am Brian Ingram. This is Carrie Olson. We're both partners at Moore Ingram Johnson Steele, and we are not workers' compensation attorneys. So we are not fun like everybody else is here. So bear with us. We're not.
We get you money back, so we're the ones you do want to know.
I practice in the area of liability defense. Carrie focuses and specializes on labor and employment law, and we both practice also in the area of subrogation, lien recovery. When the firm asked us to talk first today as the educational component of today's speaking, I thought, yes, somebody is finally excited about subrogation. They want us to go first. I realized as we started getting ready for today that it may just be that it's so awful and boring they want to get it out of the way so y'all can have fun the rest of it.
I just want to make sure you guys stay awake so we run it early.
So I'm going to assume that you're all very interested, but I'm also going to know in my heart that we're just going to try to get through this really quickly so y'all can have fun the rest of the day. But we do seriously have an important message to deliver to you today. Our goal today is to persuade you very briefly that consistently and effectively pursuing subrogation claims in all of your claims practice is worth your while. It can be a revenue positive endeavor if you consistently and effectively pursue your subrogation claims. Now to do that, we're going to talk about really three things. First, like I said, understand why you should consistently pursue these claims. Secondly, we'll discuss a little bit about the nuts and bolts, what you need to know to pursue these claims. And then we'll also discuss some of the strategies that we've been able to employ to make this a revenue positive endeavor, and make this something that's worth your while, and bring money back to your system. And to me, the first thing here, is this one? Okay. The first point is the most important part. I see it on people's face all the time if I start talking about subro. They go, really, are you serious? Well, why should I even care about this? It's the state of Georgia. Don't you know that? It's the whole state. It's pointless. I'm not going to pursue subro. But I'm here to tell you that consistently and effectively pursuing your subro claims where they exist will pay off. But it requires you to be consistent. You've got to identify every subro claim. And it also requires you to be effective in evaluating those claims. Some claims aren't worth pursuing. But if you're identifying every claim and then pursuing those that make sense to pursue, you can make this a revenue positive endeavor. And the key is, like I said, there's money out there to be had. You've just got to go get it. You've got to effectively and consistently go get it. And I want you to take away this one thing from today. Don't buy into the made whole meme out there. Everybody thinks it's a made whole state. It's not worth it. That's not true. You don't have to win the made whole argument to recover on your subro claim. You don't have to win that argument. You just have to make an argument. And sometimes you don't even have to actually make the argument. You just got to present your claim and pursue your lien. Once you protect your lien, you've got the leverage to recover. But again, that requires you to identify the claims, properly evaluate the claims, and then pursue the worthy ones and do it consistently. And as a whole, across all your claims, you will start to see that money come back into your system. And I'm going to let Carrie tell you all a little bit about the made whole pitfall and why you shouldn't buy into it.
I know we've all heard a lot about the made whole doctrine and that it's a fairly impossible standard to meet. And it is. If we actually go to a made whole hearing, which we do not recommend you do because you are most likely going to lose it. Because what does made whole mean? It's really up to the judge. It depends on the judge you're in front of. You have a bench trial, and you're going to sit there and you're going to try to explain to the judge why this dollar figure made that injured worker whole. I'm going to change it. And the way that you do that is you have to walk through every level of damages. You have to show the medicals and all the full medicals, what was actually billed out, and that he recovered every penny of that back. You have to show his lost wages and that he recovered every penny of that back. Those are the easy ones because they're actual numbers that we can look at. But there's also pain and suffering, and that's when it's up to the judge. Is the money left over after I approve the medical and the lost wages enough to make that individual whole from pain and suffering? Your guess is as good as mine. I can make a million different arguments on why it is, but it's going to be up to the judge. So, how do we avoid having to convince a judge that someone is made whole? We settle it. We settle it early, and we are a pain in the butt to those plaintiffs' attorneys until they give us the money. I recommend that you settle as early as possible. I like to approach plaintiffs' counsel as soon as I get the case and try to do a sliding scale settlement with them, which means I set out some brackets and I say, you settle your case or get a verdict from 0 to $50,000, I want 5% of it. From $50,000 to $100,000, I want 10%. And what we do with that is if they agree to a bracket and this sliding scale, then I just back out of their hair, I don't bother them, and I can actually help them out on getting that money. I sort of lost where I was, but I'm just talking here. But that's how we like to approach the May-hold, because if we actually get to that hearing, it's going to be much more challenging. Also, if they do go all the way through trial and they get that dollar figure, the problem is no plaintiff's attorney wants to talk to you anymore, because they get paid on a contingency basis. So as soon as they settle that case or they get that verdict, they're paid. So now they're working for free. This is also a great time to get them to settle with you, because no attorney works for free. So you can approach them at that point, and I tell them they have to hold their entire amount in escrow, and they can't pay their client or pay themselves until they deal with my lien, and that I'm entitled to a made-whole hearing. They start to get agitated with me. That's a good point. When they're agitated with you, it means they're going to give you some money. And that's when you can really, again, start the negotiation process while avoiding the actual made-whole argument. So like Ryan said, you don't have to win it, we just have to make it.
And to add to Carrie's point, I believe that it would be malpractice for a plaintiff's attorney to resolve his client's case knowing that there's a subro lien out there and pay the claimants, pay your claimant, the plaintiff, out of that settlement, take his fee, and wash his hands of the case. My personal belief is that is malpractice. The problem is you can't assign a malpractice, a claim in the state of Georgia. So we can't then go to the claimant and say, hey, your attorney has exposed you to me suing you to recover that lien, so why don't you just give me your claim against the attorney for malpractice and we'll pursue it in your stead instead of pursuing the lien. You can't do that in the state of Georgia. But that doesn't mean it's not malpractice for the plaintiff's attorney to do that. And I know that in a lot of cases, the plaintiff's attorneys are scared of that malpractice claim. They're scared of, like Carrie said, having to do the free work of defending their client in a subsequent suit by you to recover on the lien because they didn't satisfy it at the time of settlement. And so you're able to use that as leverage to exact some kind of settlement out of them at that time. It's also a very effective time to seek a settlement. Now, in terms of the nuts and bolts, this is the kind of the hard tack stuff that you need to know if you're going to pursue these claims. First of all, understand part of the reason we're here talking to you as non-workers' comp attorneys is subrogation claims are in reality liability claims. These are personal injury lawsuits that you're bringing either on behalf of the claimant or you're joining in the plaintiff in their effort to recover in their personal injury lawsuit. That means that these are subject to the personal injury statute of limitation in Georgia, which is 2 years on all claims. The significant part for our purposes is that Georgia law also says that during the first year of that 2-year period, the claimant is the only person that can bring their cause of action. But in year 2, on day 366, you all of a sudden have the right to bring that claim on behalf of the plaintiff. Now, that does not mean, and this is an important point, just because you're in the driver's seat does not mean that you want to immediately jump in there and file suit. Because then all of a sudden you're doing all the work for the plaintiff. They can let you file suit and jump in, once you've spent, thousands of dollars pursuing their claim and benefit from it. You don't want to do that free work for them. So, generally as a rule of thumb, we tell clients between 6 months left on that 2-year window, maybe sometimes as late as 3 months left, you want to start thinking about maybe pursuing that claim on your own. If your claimant is just totally uninterested in pursuing the claim.
And you have to be careful with that decision as well. If we're bringing the claim in the shoes of the injured worker, there has to be a reason he didn't. And that's what I always tell my clients when we're thinking about doing it. If this is a slam dunk liability case, some plaintiff's attorney would have taken the case by now and filed, which means we can just intervene and sit back. We spend very little money protecting your lien and we get recovery. If we're in the driver's seat on it, we have to prove liability. And the injured worker can come and intervene into our case and then he ends up getting paid anything above our lien. So you need to it's a difficult decision to make. You need to make sure your lien is very worth going after and that there's enough insurance money out there to make it worthwhile.
You got to have the right case to pursue it individually. Now, very briefly, to protect your lien in Georgia, there's 2 ways of giving notice of your lien. One is sending a lien letter, just letting everybody in the case that has any interest in the case know that you have a lien. Those are completely unenforceable in Georgia. It makes you feel good, and it's great to do it, and it gives you an added argument that they need to satisfy it if they settle the case, but your lien is not protected until you either file suit or intervene in the claimant's lawsuit. That's really the key, and that's the gold standard, like Carrie said, is
But still do
intervene
your
in the
lien
claims
letters.
lawsuit. Yeah.
Even though they're unenforceable, still do the lien letters so that they're keeping us apprised of what's going on. So if they don't know you're out there, they're gonna file a suit, they're gonna settle, they're not even gonna worry about you. And most plaintiffs attorneys really don't understand subrogation law, so you tell them they're enforceable, and they believe that they are. So send them out there, get them into the plaintiff's attorney's hands, and they're gonna let us know when they file a suit, or they're gonna call us when they're about to settle the case, so that we can get in there, even though they haven't filed a suit, and try to recover some money for you.
And here's my favorite part of intervening in a suit. Once you do the work to intervene, you find the claim, you intervene, you file the motion, the judge grants it, you're in the case, you do nothing. Your goal is to sit and do nothing. Spend as little money as possible. You've protected your lien. Now you just want to sit there, and every now and then you want to call the claimant's attorney and say, hey, pay me. Hey, pay me. Just be a pest.
Show up at every once in a while a deposition if there's going to be something that'll help you if you end up having to prove made whole. But really, you just call them every once in a while and shoot out emails to make sure that they know you're there. Just reminding them that they cannot settle their case without you, and they cannot go to trial without you.
Now, very briefly, again, nuts and bolts, the three elements of a valid subrogation lien. And again, this only matters if you get to that made whole hearing. You just want to be able to make an argument on these points. Number one, benefits actually paid, the injury was caused by a third party, and finally, the claimant has been made whole. And again, don't be deterred by that. What does benefits actually paid mean? First of all, we are limited to the recovery of medical and indemnity benefits paid to the claimant. That's all you can recover. If you bring a suit in your own name, or if you're intervening and somehow the claimant disappears from the case, the only recovery you're allowed is the medical and indemnity you've paid out. Anything in excess of that that's recovered in a case must be returned to the claimant. So you have no motivation to go overwork a case and try to hit a home run. You're limited to what you've actually paid out. But note the other really important thing that this means. It means that you have to have actually paid those benefits. I've seen cases, and I have one now, where we filed suit on behalf of the claimant who had no interest in doing so, said she didn't want to, only because we knew in the future, in the future we're going to have to pay benefits. She hasn't treated yet, but we know she's going to have a back surgery whenever she gets around to it. Well, we filed suit just to protect that lien, and we can't actually recover until she has that surgery. So if we can't encourage her to have that surgery before I'm forced to bring this suit to a head, we're not going to be able to recover. You can only recover if you've actually paid benefits, not even benefits that's scheduled, not benefits that you know you're going to incur. You have to have actually paid them. And finally, just remember that if they settle out from under you before you intervene and protect your lien, your right is lost. You cannot recover.
Technically, we can.
Carrie's done it in the past. She's a magician. So was the injury caused by a third party? Again, this is just some things to think about. As an auto accident, as a premises liability case, oftentimes if the injury didn't occur on your employer's property, you've probably got a subrogation claim. Was the accident caused by machinery or equipment that was installed by a third party? If you've probably got a products liability claim. That's a subrogation claim right there. Another one that I think falls through the cracks very often is even if it occurred on your employer's property, was the instrumentality or the cause of the injury something that somebody else installed? I've seen cases where you have a tile ceiling falls on somebody's head. Well, they were at their place of work, so nobody really thought maybe there's a liability claim, but hey, the person that installed that tile was a contractor. You've got a claim there. There's a subrogation claim. And the claimant figured that out. They sued. You need to figure it out too. And finally, can you prove it? We are limited, like I said, to money we've actually paid for economic damages. That means medical damages and lost wages. Now, the important part of that is, and this is really something for your attorney to deal with, or us to deal with, anytime in the case there is evidence being presented or developed of the actual medical damages or time away from work, those lost damages, those lost wages, that's what's important for us. That's the time you want to show up at the deposition. That's the time you want to make sure that evidence is preserved, because that is the evidence of your claim. And that's really the key for you. And what that means is, like I said, you want to make sure to preserve that evidence, and also, in order to have that evidence identified by the jury, you are entitled to request a special verdict form. This is important. You have to do this once you're in that case. Request a special verdict form, because if the jury returns a verdict and just says, we find for the plaintiff in the amount of $1 million, you've got nothing. Because that $1 million is, who knows how much of it's mixed up with their pain and suffering, who knows how much the jury gave them for their actual medical costs and lost wages. You have a right to ask the judge, to ask the jury, to specify they are awarding pain and suffering in the amount of X. They are awarding economic damages in the amount of X. And it's only when you have it specified like that can you recover, can you make the argument that the claimant has been made whole in terms of their economic damages.
And that's where we do run into more trouble with the made whole doctrine and the settlements, because every settlement agreement is going to say, it's $1 million and it's $1 million in pain and suffering only, we just waived medical and lost wages. That's to try to prevent us from recovering. So we do have to get more creative in our arguments in that case because it's not set up the way it is in a special verdict for. Most of those agreements also say he's not made whole. That's unenforceable. They can't just contract my rights to prove made whole away. So those lump sum settlements, a lot of lawyers attempt to argue that just because it's lump sum means I can't make my argument. Well, there's case law out there that says I get to make the argument and I have a right to make the argument. So don't be discouraged if you see a lump sum settlement.
I'm going to kind of jump ahead a little bit and make sure that we just very briefly touch on something else I think is important for everybody to remember. In the workers' comp context, the claimant is entitled to payment no matter what, right? Immediate compensation for an injury. There's no question of liability. There's no question of who's responsible. Were your medical damages really caused by this accident or something else? Doesn't matter in the workers' comp context. That is what it is all about in the liability context. So remember, in your subro claim, you're fighting very different issues than you are in the workers' comp context. The plaintiff has a duty to prove, must prove duty, breach, and causation and damages in the liability environment. Now remember also, the liability environment is a little more slow moving. I liken it to a slow moving cruise ship, right? Everything moves kind of slowly, but you have hard and fast deadlines that come up, and there's no redos in the liability setting. When you have a deposition set, if you don't have your evidence in place, you don't have your questions in place, you don't have your witnesses interviewed, you've missed your opportunity. You don't get a second bite at that deposition. You don't get to reschedule it. There's not a bunch of hearings to resolve little issues as you go along the liability setting. It's a slow-moving ship, but if you get off the boat, it leaves you behind very quickly. So remember that. And remember that that means that you've got to corral your evidence, both lost wages, economic damages, early. Get your hands around the things you need to prove your claim early. And then finally, just kind of sum up on the subro side, is it worth pursuing? Like I said at the beginning, yes, generally subro claims are worth pursuing if you're evaluating them and identifying them consistently. You can make this a revenue positive thing for you. And I like to remind people, to the extent that you feel bad taking money from a claimant that was really hurt, remember, and I see somebody shaking their head, you should, remember that the claimant, the person you're paying, gets to go to the liability lawsuit and act like they paid those bills. And not the fee schedule bills, but the full freight, the individual cost that the medical provider would charge you if you just showed up off the street and required a surgery or whatever your case may be. So remember, they're pretending like they're paying the bills that you're paying. So don't hesitate to jump in there and try to get paid back. This is your chance to be a plaintiff too. There's money out there to be had, so go get it. And just remember, you have to evaluate them realistically, and remember what you stand to gain by pursuing your claim. Be alert to the timelines. Remember that liability it's a different environment than comp. Remember that you're going to move slowly, but you've got to get on top of your evidence immediately. And finally, like I said, just if everybody puts in place a comprehensive strategy to identify their claims and pursue them effectively, you will make it a revenue positive experience for you. And there's just no reason to not go get the money that's sitting out there for you. And to end, Carrie is, like I said, a specialist in, totally switching gears. Carrie's a specialist in labor and employment law, and she's going to tell you about some new developments in drug testing regulations that were just issued by OSHA.
Yeah, this is just going to be a quick one. We've gotten a lot of questions about this since this regulation came out. And OSHA decided to tell everyone that they cannot do mandatory drug testing after a workplace injury because it could be retaliatory, which made every single one of you and me go, what the heck are they talking about? We have to do drug testing after a workplace incident if you want to do a Georgia drug-free workplace, if you want to comply with the Workers' Comp Act. So, we did some digging into this, and essentially what they're concerned about is motive. And they don't want people to be discouraged from reporting these workplace injuries because they feel like they're going to be retaliated against. But if your motive is to comply with some state or other federal law, you're allowed to drug test. So the moral of the story is don't ignore OSHA completely, but continue to drug test after a workplace incident. And that's quickly, because we're running out of time.
Thank you all very much. If you have any other questions about Subro, give us a call. We'll be happy to help you. And thanks for your time.